Okay, so let's get the show started. So welcome everyone to this REACHLaw webinar on UK REACH, EU REACH, and Turkey KKDIK only representatives. And we'll be looking at confidential business information issues and also supply chain complexities and considerations. So today I will be your only host. My name is Fredrik Johansson. I'm a partner, head of sales at REACHLaw. I have a long background in chemical regulations and I've been working a lot with only representative topics related to all these markets that we're talking about, so the EU, UK, and Turkey. And I will try to guide you through this sometimes complicated field that we are having as a topic subject for this webinar today. So as for those of you who've attended our webinars in the past, this is the familiar, let's say, format to use. So you can use the chat function to ask questions during the webinar. We'll try to answer all of those questions, or as much as possible of those questions at the end of the webinar session during the Q&A part. And the questions that you have been sending in ahead of this webinar, we will answer those, at least as far as those questions pertains to the subject at hand of this webinar. If we are not able to answer all your questions, of course, we'll get back to you by email. And as of late, all of our webinars will be posted to our YouTube channel, which is it's called REACHLaw Talks. So please head over there to see our webinar recordings, past webinars, and of course this webinar will end up there also. And of course, in any case, please do send us feedback. We appreciate that very much. So the agenda for today will be a busy one. So you can probably expect this webinar to probably spill over a bit more than 60 minutes. So my apologies for that in advance, but as for those of you who have seen me before, you know that I tend to have a lot of slides, and this is no exception. So today, first we'll look at REACHLaw in brief, so who we are and what kind of services related to this topic at hand we can provide. Then we'll have a fairly, I would say, fairly comprehensive look into only representatives. So who are those who can appoint an OR and so forth, to give a bit of background into the next sections, which will be confidential business information considerations, and also discussing about indirect import and complex supply chain setups where there are multiple only representatives representing substances as part of a mixture that is placed, for example, on the EU market or the UK or Turkey markets. Then we have also some, I would say, creative solutions for OR appointment for those of you who cannot appoint an OR yourselves. And then we'll end up with conclusions and Q&As at the end. So REACHLaw, who are we? So we are providing support for REACH and REACH-like chemical regulations globally. So obviously this now encompasses the regulations that we will be talking about today, which is obviously the EU REACH regulation and then the UK REACH regulation, as well as Turkey KKDIK. But beyond this, also India REACH and K-REACH, and India REACH when it enters into force, and K-REACH, we are also providing support through, albeit through our partner. So we have offices in all of these areas where we just mentioned, where we are, for which we are having the topic discussed during this webinar, that is EU and the UK and Turkey. So of course here in Helsinki, we have the head office at REACHLaw servicing our EU and non-EU clients for EU REACH purposes mostly. And then in UK, in Manchester, we have an office servicing UK REACH and providing all our services there. And then in Istanbul, in Turkey, we're providing, of course, Turkey KKDIK related services, as well as only representative services for the Turkey market. And then we also have a small office in Brussels and a bigger one in New Delhi servicing Indian clients, and India REACH whenever that will come into force. So we provide really a full set of market access services for chemical products. So this of course, entails providing only representative support services for various markets. We'll talk about this in just a second. But also the more demanding work such as lead registration, authorization, and then of course the more standard work such as co-registration and related consultancy, SDS work, CLP and classification notifications, labelings, and also other more, would say, advanced services related to circular economy and sustainability services. We also provide consulting, training, and other technical and legal services in these in the scope of chemical regulations, obviously. For only representative services, we provide these, of course, the full set. So we provide OR services in these countries, as mentioned, so the EU, the UK, Turkey, and then through our partners in Korea, for example, and India reach to come. But then also all the related services, such as, for example, if you need to change an OR, we can definitely help you with that, whether there's a consent or non-consent from the existing OR. Of course, we provide volume tracking services, providing certificates, trustees, all the related consultancy and SME verification services, which are relevant when you're registering substances in these markets. If you want to benefit from lesser registration fees, and of course providing compliance certificates and managing confidential business information, on top of course providing all the other basic regulatory services such as registration and so forth. So in brief, you can say that we specialize in chemical regulatory compliance and sustainability. So as mentioned, we have our YouTube channel called called REACHLaw Talks. It's on YouTube, yes. So please head over there and you can find, as said, dedicated YouTube content, but you can also find our webinars there. So please, if you like, please subscribe and click the notification bell. Then you will, of course, be notified when we upload new videos. And if you like those, please consider giving a thumbs up. Okay. So before we head over to the topic at hand today, I also just want to give you a quick regulatory update of what's happening next. So if we start with the UK REACH regulation, at the moment there's a possibility still to late do notify substances that can benefit from these so-called transitional registration deadlines. There's a discussion ongoing pertaining to a new registration approach in the UK, which means that for certain substances of lesser concern, you would be able to submit only publicly available information and you would not have to buy additional data. And thus, this new approach also stipulates that there will be postponements of the registration deadlines that have been included in the regulatory text. So at the moment, it looks like the first deadline will be postponed by 3 years, the next one with 1 year, and the last one with also 1 year, or the second one maybe with 1.5, depends on. But this is still up in the air, so it's something that we'll probably know more in the fall. On top of that, lead registration work is already ongoing in some cases, and some dossiers have even been submitted. More or less the same status is with Turkey KKDIK, albeit there are no changes to the registration deadlines. So the late pre-registration phase is still ongoing, and that goes on until the end of the registration deadline, which is end of next year. So there's a lot of activities with lead registrations at the moment, preparing these lead dossiers, negotiating access to data, and of course submitting these to the authorities through the KKS system. Also, we are starting to see the first letter of accesses being available for co-registrants to purchase, and then also go ahead with the co-registration work, ahead of the, of course, deadline by end of next year. India REACH, that is still pending, and we're following the situation to see when actually this regulation is entering into force. At the moment, it's still up in the air, so very likely not this year. For K-REACH, the next registration deadline is end of 2024 for the lesser tonnage band of 100 to 1,000 tons, and that is already something that companies are preparing for. For e-REACH, actually, it's not included in this slide, but of course, we're following, for example, the REACH review process very closely, which will have a separate webinars in due course. And we've actually had them already, so you can see at least one available on our YouTube channel. But there will be subsequent webinars following up on that topic as more information becomes available. And for those of you who are actually traveling to different venues, live venues, maybe you've already seen us at some of these, like ChemSpec last week or Surfex this week. But if you're still catching up, then we will be at the Chemical Watch Expo next week in Amsterdam. After that, in ChemCon Europe in London, and later on in Turkchem in Istanbul in Turkey. So, all right, of course, also as we're providing a lot of information, it's very important for you to understand the disclaimer and copyright information. So please feel free to look at this in more detail in the recording. But essentially what we say is that any actions you may take based on this presentation is of course under your own responsibility and risk. So no representations or warranties are made with regards to the completeness or accuracy of the content in this presentation, and no liability is accepted by REACHLaw in that respect. So there goes the legal disclaimer. Okay, now going into the details that we are waiting eagerly for. So just to note that the presentation assumes that you have a certain basic understanding of the registration requirements when it comes to e-REACH, UK REACH, and Turkey REACH. Actually, it's enough for you to understand one of these because they are essentially very similar, except for maybe UK REACH, which is deviating a bit with regards to the registration requirements. But nonetheless, having a basic understanding definitely helps. So we will not go into the backgrounds of these regulations per se. We are focusing on only representation and related issues in this presentation. And just a heads up, my slides contain a lot of text, so sorry about that. A lot of information packed. Okay, so just to conserve a bit of bandwidth, I will just turn off the camera for a while so that we can concentrate on the information in the slides. So we'll start with only representatives. Who are those? Who can appoint an OR? What are the basics essentially, and probably going a bit more into the advanced issues also. So looking at only representatives, this it is good for you to understand that without going into the details here, the only representative concept, as was essentially envisaged, if you will, by the EU REACH regulation back in the day when it was drawn up, has been copied over to both the Turkey KKDIK regulation as well as UK REACH. To the UK REACH regulation, of course, due to the reason of Brexit, because they have transformed the existing EU legislation to a high degree, including the EU REACH regulation, into national UK law. And in the UK REACH, of course, entered into force at the beginning of last year. In Turkey, the KKDIK regulation is a copy of the EU REACH regulation due to the willingness to align national law with the EU for the hopes of maybe someday becoming a member of the European Union. So in the EU REACH regulation, the only representative concept, if you will, is defined in Article 8. In the UK REACH regulation, it's under Article 8, and then these special provisions related to the transitional measures and adaptation to national law and national situation in the UK, Article 127 EA of this UK REACH, which is called the REACH, etc. amendment, etc. EU exit regulations of 2020 as amended. There have been several amendments since then, but this is the basic. So it stipulates the requirements for OR, and then in Article 9 of the KKDIK regulation, the OR requirements are stipulated. And as said, this concept is the same across all of these regulations. So essentially, the legal text is a copy, and you will see this in a few slides. So when going over some of the basics, we'll just show this from a EU REACH only representative perspective, because this also applies for UK REACH and Turkey REACH in the same way, essentially. So when you see in the next few slides, EU REACH mentioned and the European Union and the European Economic Area, you can just essentially replace those with UK REACH or KKDIK and Great Britain and Turkey. So how can non-EU, non-UK, non-Turkey companies register in the applicable markets, so meaning EU REACH for the EU and UK for Great Britain and KKDIK for Turkey? So of course the EU, now again looking at this from the EU REACH perspective, so the EU regulations only have, of course, jurisdiction on legal entities in this location. So it means that if you're outside the EU, then of course EU REACH does not apply to you. So you do not have any obligations, obviously. So the default, if you will, is that if you are a non-EU company and placing chemicals on the EU market, then your importers in the EU would take care of REACH compliance. This meaning, for example, registration. However, there is actually a more efficient way for these non-EU companies to access this EU market for substances subject to registration. And this is the only representative concept. So under EU REACH Article 8, these non-EU and non-European Economic Area companies that manufacture a substance or formulate a mixture have the right, not the obligation, but the right to appoint an only representative to take care of EU REACH importer obligations. So what this means is essentially, in this context, registration and related activities. An OR can also represent a non-EU entity for authorization purposes, but we'll not look at that actually in this presentation. This will be very much registration focused. So benefit of this appointment of an only representative is that all customers, all importers in the EU who you send your chemicals to as being a non-EU manufacturer or formulator will be construed and considered as downstream users if they are covered by the only representative. So this essentially means that you can get by with just one registration covering all imports into the EU by multiple different companies located anywhere within the EU or the European Economic Area. And that is what makes this efficient, because essentially if you have two or more customers, then you're already saving on the registration costs. Other benefit is, of course, that if you are have appointed an only representative, then of course, and you have clients who are importing the substances from you through the that are relying on the only representative, then they can of course only import from you these substances, because the only representative is connected to the manufacturer or formulator who has appointed the only representative. They cannot import the same substance from anywhere. However, if they would register as importers, then they could import the same substance from anywhere outside of the EU, as an example. So those are the benefits and the small drawback, if you will. So I will not go into the details of the legal text, but you can see comparing the EU REACH Article 8, UK REACH Article 8, and the KKDIK Article 9. Sorry, there's a typo there. You can see essentially that the legal text is very similar. So they have all three paragraphs, and these paragraphs are of of importance, and I have summarized them in the next page. So this first paragraph talks about appointing an OR to take care of these EU REACH or UK REACH or Turkey KKDIK importer duties. The next paragraph states what essentially qualifications, if you will, the OR needs to have. So they have to be multidisciplinary, background in chemistry, law. They have to have procedures in place to manage data. So essentially an IT system, they also have to have an organization in place who can handle these requirements as placed on the OR. We'll look at that in a second. And paragraph 3 stipulates that subsequent importers will be regarded as downstream users if covered by the only representative. A very powerful part of the only representative setup. So who can appoint an only representative? We already looked at this in brief, but essentially a company that is located outside the jurisdiction that we are looking to register, for example, a substance in. In this case, for example, if we again take the EU, if you have a company outside of the EU who is either manufacturing a substance and or formulating a mixture from substances or other mixtures, these are the types of activities of a non-EU, non-GB or non-Turkey based company that can appoint an only representative in these said jurisdictions. If you are not manufacturing or formulating outside of this jurisdiction in question, then you cannot appoint an only representative. That is very important to understand. So this means, for example, that chemical traders outside of a said jurisdiction, for example, the EU for EU REACH purposes, cannot appoint an only representative, as they typically are not manufacturing or formulating mixtures, manufacturing substances or formulating mixtures. So that is this is I would say a fairly common question we get, and lamentations, if you will, by traders saying that they would very much like to appoint an only representative to retain regulatory control of the supply chain, but they cannot because they're not manufacturing a substance or the substance in question, or they're not formulating a mixture. So what this looks like in practice is I have 3 cases, one for each, so EU, the UK, and Turkey. So they're very similar. So I would just go through the first one because they are essentially identical, the other ones. So on the left-hand side, we have a case of import by customers. So these are customers C1, 2, and 3. It should be at 3. So these are importing the same substance AB from, for example, the US, from a manufacturer of this substance, or if it would be a mixture or formulate. So each of these, if we just consider this as one substance, then each of these being importers would have to register the substance, each of them, provided the tonnage band is exceeded. So the 1 ton threshold is exceeded. So it means that you have to do 3 registrations to get the same market penetration, if you will, in this case. So it's 3 times cost, 3 times the effort, more or less, depending on the volumes, annual volumes, of course, you're registering. But let's keep it simple and just say that it's more or less 3 times the effort. However, on the right-hand side, if this manufacturer or formulator, let's call it the manufacturer in this case, in the US, would appoint an only representative to take care of these importer obligations, so meaning registration in this case, this OR would do the registration once and cover these customers 1, 2, and 3, again should be a 3, under their 1 registration. If they are covered by the OR, then these will be seen as merely downstream users from a EU REACH perspective, even though technically they are the importers of these substances directly from this manufacturer in the US. But due to this OR concept, the OR can cover the regulatory importer requirements on all of these importers, thus them coming downstream user, meaning that instead of excuse me, doing three registrations, you can get by when doing just one registration. Obviously, doing this one registration, you will have to add up all the volumes of each of these. So in effect, it might be that you have to register a higher volume here than you did in this case. But anyway, the effort is more or less 3 times less. So you can see that appointing an only representative is very efficient in these cases where you have several downstream users, several customers in this said market. In this case, it would be the EU or the European Economic Area. So won't go into the details here, but the same applies for Turkey. Okay, in this case, it's a wrong flag again. Sorry about that, but essentially it means that if you, for example, are no, sorry, this is correct. So if you are a Turkish manufacturer, for example, placing substances on the UK market, again, if you don't have an OR, each importer will have to register individually, whilst if you appoint an OR in the UK, then this OR can do take care of these importer obligations centrally, cover these importers so that they become downstream users and get by with just one registration. And the same for Turkey. In this case, it would be a British manufacturer who places chemicals on the Turkish market. Three registrations with no only representative versus one registration with an only representative. So very efficient way of using an only representative is to get coverage of multiple clients with just a single regulatory registration effort, for example. So these importers within the same supply chain covered by an only representative are relieved from their registration obligations, as they will be regarded as downstream users. And this is the power of the only representation, is that they become downstream users. And downstream users, according to all of these regulations we're looking at, do not have registration obligations. It is only with the importer, in this case, the only representative, who takes upon itself the importer obligations and centrally registers, for example, the substance just once. So looking at the responsibilities of the only representative, try to pick up a bit of speed here. So essentially all the tasks of the registrant or authorization applicant or notifier of substances of very high concern and related updates can be handled and should be handled by the only representative where applicable. Then they need to keep up-to-date information about the customers, so the importers in these said jurisdictions, and the annual volume provided to this jurisdiction per customer. This also includes so-called indirect import volumes. I will talk about this in a bit. They need to keep available, of course, all these applicable compliance documents, such as appointment letters, lists of substances that are covered by the only representative. Then, of course, if the OR has performed registrations, CEF agreements, letter of accesses, and so forth. They also need to respond to authorities' requests for information, of course, need to communicate with customers, CEFs, and consortia related to registration and keeping those registrations up to date. They also manage confidentiality between different parties in the supply chain where applicable, and we'll look at this in a bit also. Optionally, they can also keep available and provide up-to-date safety data sheets, and this is a bit case dependent. I will not go into details on this. So the ECA guidance actually says that as an only representative is fully responsible and liable for fulfilling all obligations of importers for the substance he is responsible for. These do not only pertain to registrations, but also to all other obligations of importers under REACH. So this is also, again, a fairly powerful statement saying what are the the responsibilities, obligations, and also liabilities of the only representative. And a great deal of competence and expertise, whether it be technical, legal, chemical, organizational, business, etc., IT, is required actually from the only representatives to fulfill these said regulatory obligations. So I would say not just anyone has what it takes to become an only representative. They have to have a unique skill set. And just to shield REACHLaw a bit, we have those competences, which should not be a surprise, of course. So how does the appointment of an only representative work? So of course, first you should contact a competent only representative to get a quotation for these type of services for the said market, so EU REACH UK or Turkey KKDIK. If we use REACHLaw in this case, then next, provided the proposal would be accepted, then we would draw up only representative agreements, including appointment letters and substances covered agreement files. So once those have been then signed by the in this case, for example, non-EU manufacturer or formulator, then once those are signed, the only representation is in force, and we would start to set up all the applicable REACH IT accounts or accounts in the different IT systems. REACH IT comply with UK REACH for UK REACH purposes, and the KKS IT for KKDIK purposes. And of course, start our internal management processes and then inform the supply chain of this notification and take it from there. It's also good to understand that you can, and it is definitely possible to change your only representative if you are not happy with your current only representative for EU REACH, UK REACH, or KKDIK purposes. The change is, funnily enough, not envisaged in the regulation per se, but there are processes available for this. And in this example, we'll look at EU REACH example where we get a consent from the old only representative for transferring the only representation to a new only representative. Excuse me. So the EU REACH actually has, I would say, the most sophisticated system for transferring only representation versus, for example, the UK or Turkey. So for EU REACH, what it looks like is, if you want to change, then this non-EU manufacturer formulator would send out a termination agreement to the old one, also covering the transfer of registration. So saying what registrations assets essentially are within the scope of this termination. Then next, or in parallel, there would be a new only representative agreement, appointment letter, and an agreement set up with a new only representative. And of course, this termination can also be managed by the new only representative. So for example, if REACHLaw would do this, we usually assist the client in this termination process. Once the agreements have been agreed to, then there's a REACH IT handshake procedure, meaning the information is transferred in REACH IT to the new REACH IT account of the new only representative. And once this is done, then essentially the new OR has become the only representative of this non-EU manufacturer in this case, and will inform the importers of this only representative change. There might be, of course, subsequent update requirements to the dossiers and stuff like that, but that's the technical work that precedes then this change. So the idea is that this transfer of these assets, so for example, registrations, notifications, inquiries, and whatnot from this old OR to the new, is done through a legal entity change. And in the EU, this costs something. So for large size enterprises, it's around 1,600 euros, if I recall. However, for Turkey and the UK, it's not as handy. You have to do this manually by contacting the authorities. So the HSE in the UK and the Ministry of Environment and Ministry of Environment and Urbanization and Climate Change, respectively. So it is not possible directly in the IT system, at least currently, to do this change. So it is a manual process for your information. Okay, so coming to confidential business information considerations. And before that, let me just have a sip of tea to guard my voice. So confidential business information considerations for the only representation. So by nature of the only representation, actually the only representative appointment already is a sort of guard against or a protection of confidential business information. For example, if you then appoint an OR and they take care of the registration requirements, then these registrations will be made in the name of the only representative. This means that in any dissemination tools for EU REACH or in any CEFs, for example, in Turkey when you're registering for KKDIK purposes, or any substance groups when registering for UK REACH purposes, only the only representative will be shown, not the actual company, the manufacturer formula who has appointed the only representative. The who has appointed the only representative is not public information. And it is also good to know that even though maybe, for example, some of your competitors might know more or less who the only representative is, though, if they, for example, look at what substances the OR has registered, for example, on the ECAWeb dissemination tool, if they look at, for example, REACHLaw, they will see that there have been hundreds of different substances registered, and they cannot generally pinpoint what substance is REACHLaw representing for what client. So it's just a list of substances covered by REACHLaw as a registrant. If needed, additional measures may be taken by claiming actually the substance ID confidential, but we will not go into details. This goes into a lot of technical stuff, but it is possible to further guard the identities of the substance, for example, from any other actors who might otherwise see this identity of the substance, coupled with to the only representative as the registrant, for example. And of course, good to know that the identity of the manufacturer formulator who's appointed the only representative is, of course, always visible to the authorities. So, for example, in the EU, when you submit dossiers, you submit also appointment letters. In Turkey, you provide, and the same applies to UK, and in Turkey, you provide this information separately in the KK system. But this is not visible to anyone else except the authorities, so good to know. Besides the previous, if a formulator of confidential mixtures wishes to place this mixture on a market, for example, in the EU, Great Britain or Turkey, using an only representative, then of course it is possible, and it is by default already possible for this only representative to keep these substances confidential from the customers who are receiving these substances as importers, for example, in the EU or Great Britain or Turkey. So it means that we do not, as an only representative, have to disclose the composition of a mixture to the customers receiving this in the said markets. The only exception is that, of course, hazardous substances that need to be disclosed, what above a certain concentration in an SDS, of course, it will be disclosed. Those cannot be by any practical means guarded from let's say, from not being shown. There are exceptions in the CLP where you can apply for different measures to increase the confidentiality, but we will not go through those in this presentation. So having an OR in this case of a confidential mixture has great benefits, because if you would not have an OR, it would mean that importers would have to take care of the registration of these individual components of this confidential mixture, and you would have to provide them with a full composition. Otherwise, they could not perform their duties. But if the OR does it, then you would not have to disclose the composition to the downstream users. And you can also have actors in the supply chain, especially in cases where you have complex supply chains with multiple owner representatives covering substances as part of the mixture, confidential mixture that is placed on a said market. You can then enter into further NDAs, further protecting the confidentiality of substances, for example, included in this confidential mixture. This will actually be discussed in the next sections of this presentation in more detail. Okay, looking at indirect import and then this complex supply chains with multiple ORs case. So those will be fairly complicated slides, so please bear with me. The indirect import is a bit simpler, I would say. We'll start with indirect import. So under an only representative setup, the indirect import into a said market means that the manufacturer of the substance does not necessarily know that one or several other companies outside of this said market, for example, the EU, is also supplying this particular substance or substances to this market. You'll see this in the next slide to explain it a bit more visually, if you will. Only representative coverage is also possible in these indirect import cases. However, this OR coverage cannot be given unless the following applies. So it means that the OR is allowed to cover indirect import by this company who has appointed them as an OR. In most cases, they do provide this. I would say this is a default, that the OR can also be allowed to cover indirect import cases. And of course, that the annual volumes of a registered substance permits it. So of course, if you are already importing at 999 tons and your registration is just from 100 to 1,000, then of course, there's not much volume you can allocate to this indirect import. So that could be something you would have to check with the manufacturer formulator who has appointed the only representative, whether they want to then increase the tonnage band of the registration where applicable. So important to understand that this indirect only representative coverage is not mandatory, and it is at the discretion of the manufacturer formulators appointed the only representative, whether to support this indirect import or not. So next, let's look at this visually, and maybe it makes more sense. So now we have a standard case, if you will, of only representation. So if I take my laser pointer again, we have a manufacturer formulator. Let's call it the manufacturer to keep it very simple, that they're placing a substance on the market here in the EU as an example, but the same applies for Turkey and Great Britain. So you can just consider this case as analogous to them. They have appointed an only representative who is currently covering 3 importers of the substance under direct import conditions. So this means that the manufacturer and formulator is directly supplying the substance, in this case, to these customers. And the only representative knows these customers and covers them, in other words. If a customer, an importer, is not known to the only representative, they cannot cover them. Therefore, the only representative always have to know who are the recipients of the substances to a said market from this company who has appointed the only representative. However, when it comes to indirect import, it means that you may have one or several companies outside of the said market, in this case, for example, outside of the EU, or the European Economic Area, who are also customers of the manufacturer formulator, who are then maybe repackaging the substance and then subsequently providing it to another customer down the supply chain, who is not anymore visible to the manufacturer formulator, who then in turn places this substance on the market for new other customers. So for this construct to be allowed, the only representative must know who these customers are. They must know the volumes that come from this company supplied into the said market, in this case EU, and they must have permission from the manufacturer formulator appointing the only representative to also cover indirect import. If it is okay by the manufacturer formulator, they have said that yes, we are also covering indirect import, then by all means the only representative can do this. And in many cases, this particular actor in the supply chain do not want these customers to be known to the manufacturer, because they might be competitors in some sense. Therefore, in some cases, the only representative and this actor outside the said market who supplies these chemical products to this market can enter into a non-disclosure agreement. It means that this only representative actually knows more about the whole market for this manufacturer formulator substance, for example, in this case in the EU, than the manufacturer formulator themselves, and will not disclose information about these manufacturers or anything else to, these customers to this manufacturer. So this is called indirect import because it comes indirectly from the manufacturer formulator appointing the OR into the market. And in some cases, only the only representative will know this. In some cases, this company says that we don't need an NDA. It's fine to tell the manufacturer formulator about us. And in those cases, we disclose the information, and that's fine. But if they want to keep things confidential, then an NDA is in place. Typically, of course, if they ask us not to disclose, we would not disclose regardless whether there's an NDA in place or not. But in some cases, they wish to have it. So very good to understand that the only representative is taking care of these importer obligations centrally. So in order to be covering these also under the OR appointment, meaning that they will not have to do their own registrations, the only representative must know who these are and must know the volumes that they are importing. So how does then the only representative get to know the indirect importers where permitted by the manufacturer formulator, of course? So typically, in this case, the manufacturer formulator would inform relevant clients outside of the said market that they have appointed a only representative, for example, for e-reach purposes, for e-reach, and if there are any indirect cases, then you should contact the only representative directly. This information can in some cases also be included, for example, in the safety data sheet or in other product communication. But essentially, the information should come from the upstream manufacturer formulator who's appointed the only representative. Then it means that these indirect importers can then directly contact the only representative to seek this coverage. So it is good to know that, of course, in those cases, we need to have a permission to cover indirect imports, and of course, then see to it that if these indirect importers want to be covered by an confidentiality agreement, then this is done, and then we would not disclose information to the upstream manufacturers or formulator who has appointed us as the only representative. So as mentioned, this really means that in practice, in some cases, we as an OR know a lot more about where customers who have appointed us as an OR, where their substances end up on a said market, for example, in the EU or Great Britain or Turkey. So that covers indirect imports. So it is possible, definitely possible, and something we do on a regular basis at REACHLaw as an only representative for our clients, for EU, for the UK and Turkey. So the next, just to keep things even more complicated, let's look at the complex supply chain case involving confidential mixtures. So meaning that the composition of a mixture is confidential as far as allowed by the REACH regulation in this case, meaning that certain substances, of course, may not be allowed to be kept confidential due to the hazard properties and concentration in the mixture. But let's assume that, that all in these cases can be seen as confidential in the next example. And then each of these substances has, for example, a separate only representative covering these substances for a said market, like the EU, for example. So it is a complicated case, to say the least. So this is the eye exam for today. So in this case, we'll look at EU REACH again. But again, it also applies for UK REACH and Turkey KKDIK. So in the example, we have a non-EU and EU. So we have a formulator, an F1, who is formulating a confidential mixture composing of 3 substances, substance 1, 2, and 3. Manufacturer of substance 1, so M1, has appointed a separate only representative only to cover this one substance. They're also supplying this substance directly to their own customers, not just to this formulator formulating this confidential mixture. Then they have a manufacturer of the substance 2, who is actually has not appointed an only representative. So in this case, the formulator is appointing an only representative for this particular substance. Then we have the substance 3, which also has a manufacturer who has appointed yet a third only representative for the substance 3, and they're also supplying this substance directly to their own customers, but also indirectly, as with substance 1, indirectly to this formulator for them to formulate a confidential mixture and place it on the market in the EU to their customers, so customer 1 and 2. So this F1, because they are formulated, they can also appoint an only representative for the substances in this formulation. So in this case, as they are covered, and they have the manufacturer 1 and manufacturer 3 have indicated that they are supporting indirect import. They are covered, so they do not have to do have to have their only representative also cover those substances. So their only representative only covers this one substance, this substance 2. So this means that for this construct to work, it means that we this only representative 1 of this customer needs to know who those customers obviously are. They need to know all the other volumes going to these customers, that's standard. But also these only representatives that are representing these other substances, which this one formulator only representative not covering, they also need to know who these customers are, because otherwise they cannot provide coverage for this substance for their import. And the same goes for this manufacturer 3 OR. They also need to know who these customers are of this formulator 1 so that they can provide coverage. Because if they don't, they cannot cover that those customers, and thus they would not be covered for compliance, meaning that they would be construed as importers, and they would, as this is confidential mixture, they would not know what substances to even register. So that would be a bit of a predicament. So what this means also is that because they are covering these customers of the formulator, essentially these manufacturers, one or the only representative for manufacturer 1 and manufacturer 3 would also need to know the composition of the confidential mixture for the purpose of being able to break down the chemical composition of this mixture to be able to, for example, calculate the annual volumes. In some cases, this can be the confidentiality may be able to be retained, but in most cases, these will need to know the composition to be able to break down the volumes. So what this means is that we have a situation where this confidential mixture composition, which is CBI information and guarded by this formulator, is known to quite a lot of companies. Besides that, these companies are also knowing who the customers are of this formulator, which is probably also sensitive information. So how can this be dealt with in practice? So what you can do is that you can enter into an NDA then with these only representatives directly. So this is analogous to the indirect case we looked at previously. In this case, the formulator would enter into an NDA with this OR to provide them with this information about the confidential mixture so that they can understand the substances and especially the volumes of this confidential mixture so that they can report and cover it. The same goes for this number 3. So you can see that already here we have a situation that a lot of confidential business information needs to be shared with different actors in the supply chain. So it can easily become quite a nightmare to manage this. Think about, for example, you have a mixture where you have 10 substances, as of which 8 are confidential, and you have 10 of those mixtures, different mixtures with different substances. It easily becomes quite complicated, I would say. Here also, of course, this only representative could enter into an NDA with this OR to provide the same information. But in this case, we just assume that the formulator has done this. So it is possible to protect the confidential business information, but it is very burdensome, as you can see. So it's a lot of management of different NDAs and the confidentiality thereof. And of course, it becomes even increasingly difficult when there are more actors, more substances, part of confidential mixture, more confidential mixtures placed on the said market. Also, one of the challenges in this is that how do you provide compliance certificates to your customers? REACHLaw, for example, we provide regularly compliance certificates for mixtures, for confidential mixtures, and that is fine, but it becomes difficult when you have different only representatives that you need to essentially consolidate their compliance certificate into a consolidated compliance certificate. So what can you do in these complex cases then with these multiple only representatives? As this formulator, this is I'd say a fairly specific case to cases where you are a formulator of confidential mixture. You can appoint an only representative for some or all of the substances. Obviously, the best solution is, if just possible, just appoint the OR for all of the substances as part of the same confidential mixture. It just makes things so much easier. You have one point where you manage all the flow of information. However, if this is not possible, and these multiple only representatives are required or are already covering the substances, and you don't want to cover these substances yourself as part of this confidential mixture, then make sure that the only representative can support such complex cases and have experience doing so. Make sure that they can also provide this sort of a consolidated compliance certificates for these confidential mixtures. And this obviously requires cooperation between the ORs. So that's also good to know. So we as an OR, for example, for this formulator would also need to know who the other ORs are, obviously, if we are providing such services. And also just make sure that the only representative can assure the confidentiality of the mixture composition towards all the different actors, and especially, of course, the downstream users, the importers, the customers who are receiving this confidential mixture in the said market, for example, in the EU, in the example we showed. So, for example, at REACHLaw, we currently manage several of these cases and are assuring the confidentiality of these mixtures and are providing these consolidated compliance certificates for the customers, the importers, so to speak. So it is a complicated process. It is a combination of manual work with IT, but it is doable, and this is something we are providing as a service to clients and to companies who need it. And maybe just to mention in the brief slide that just blinked on your screen, of course, this also in these cases where it entails more work for these complex cases, and obviously the costs tend also to increase somewhat. Good to also know that. All right. If you are still awake, then let's go forward with the creative solutions for OR appointment, which is something we frequently get asked of. So I thought this would be also an interesting section to have included in this webinar, which, by the way, we're already exceeding the 1 hour threshold, so apologies for the delays or going over time, but as you can see, this is a complicated topic. Sorry, I had to cough there. So who can appoint an only representative? Well, we know this already. So companies who are manufacturing substances, formulating mixtures outside a said market can appoint an only representative in that said market, and said market, for example, EU, Great Britain, or Turkey. In all other cases, it is not possible. So typically, for example, we have, as mentioned, traders of chemicals, importers who want to have some sort of control of the supply chain, distributors, sometimes the importers are distributors, downstream users, formulators, etc., who would want to have, they necessarily do not want to appoint an only representative, but would want to have equal control rights, if you will, for the regulatory compliance of these products, so that they can control also the placement of these chemical products on the said market. So who would in some cases like to, and in citations, appoint an OR or have said equivalent, let's say, regulatory control? These are traders, distributors of chemicals, for example. We'll go into more details here. So these are typically a group that cannot appoint an OR because they're typically outside of the jurisdiction, the said jurisdiction in question, and are not manufacturers and formulators. And these would, in some cases, like to have regulatory control of the supply chain. So it essentially be equivalent to holder of a registration. So in other words, be more or less equivalent to an OR. Then we have others who, for example, importers function as distributors to a certain jurisdiction, a said market. They can, for example, be formulating mixtures and supply those then to downstream users. These are typically very keen on having control of the supply chain to this said market for a specific substance group, customer group, or to the market as a whole. It depends very much on the case. They generally do not want the upstream supplier, manufacturer, formulator, whomever, to shortcut them, to sell, bypass them and sell directly to a segment, customers group or segment, or the market as a whole. So therefore, these are also typically companies who would want to have some sort of regulatory control of the supply chain and the substance in question. So what this means, what can these different actors do? So in these cases, they can, for example, if they're an importer, distributor, or a trader in the supply chain, I cannot appoint an only representative. They can have and put in place a so-called special, we call it just a special only representative appointment. This may be a solution, and it works like more or less as follows. And I have an example detailing this in more detail in the next slide. So it entails that you actually agree to appoint, that the manufacturer formulator agrees to appoint an only representative such as REACHLaw using a very light approach, whereby this manufacturer, or sorry, this importer distributor then takes on the operational and financial liability on behalf of the only representative towards this only representative. So what this means is that we have a process whereby we have just one document prepared, an appointment letter prepared, and needs to be signed by the manufacturer or formulator, but that's it. All the other agreements and stuff like that are taken care of between the client and REACHLaw as an only representative. So essentially this means that the upstream manufacturer formulator who has the power to appoint an only representative does so, but does it without any liabilities or any excessive administrative work, etc. So essentially you have outsourced your responsibilities in a way to this company who cannot appoint an only representative, for example, importer or distributor. So what this means is in practice, and is that, for example, we have a standard case you can see on the slide here, whereby you have a manufacturer importer who has manufacturer formulator who's appointed who is supplying an importer distributor, in this case as an example, with said substance under direct import conditions. So they are directly supplying to this importer distributor, who has then are distributing directly these substances to their customers in this said market. In this case, it's the EU. So what this special appointment means is that the OR, before even becoming an OR, sets up an agreement with this importer distributor, so that this importer and distributor takes upon themselves all the liabilities, financial and other, of only representation to be set up. The next step is to have a very simple document without any strings attached, any liabilities, etc., being signed by the manufacturer formulator. Because this is a very simple appointment letter, including an exclusivity note and maybe an NDA in some cases, the manufacturer formulator has less reasons not to sign it. At the end of the day, of course, if they don't sign it, then this special appointment falls apart. It doesn't work. On top of that, the distributor importer, in this case, as an example, can also have a separate business-to-business agreement between this manufacturer formulator, but it's really not needed. Usually, if this is requested to maybe specify some exclusivity rights and stuff like that, this just complicates the process. But as long as we just have one simple document to sign by the manufacturer formulator appointing an OR, and the importer distributor taking care of all the responsibilities, liabilities, financial and otherwise, of a normal appointment, then that is fine. So what this means is that if there are any other, if this manufacturer formulator would supply directly to a third customer in the said market, it would not be covered by the only representative. So in a sense, this only representative could simply say, as part of the exclusivity in this appointment letter, say that fine, you can supply to the customer 3, but in this case, we will not cover them, and they would be considered as an importer, and they would have to do their own registrations. And of course, this can also go through other parties outside the said market, meaning that this would be indirect import. We'll not go into the details here. So in essence, it means that this only representative is really in a position of control and controlling the coverage of the substance to the said market, because only importers that are covered by the only representative, only those can import this substance without regulatory consequences to this said market, in this case the EU. If they're not covered, they will have to go through the registration route, and this is fine. So this essentially means that the importer distributor who has signed this special appointment service is actually in control of the supply chain in much the same way as the manufacturer formulator in normal only representative setups is. So this is one solution, but the point is that unfortunately we always need at least this one-page document appointing the only representative by the manufacturer or formulator to be signed and given to us. Otherwise, it will not work. And also a good thing to realize and understand that this manufacturer formulator cannot appoint another only representative for the same substance. Therefore, this OR in this case also given additional control of the situation, and therefore the client has this additional control of the situation. So maybe a good point. It was mentioned in the slide, forgot to mention it. All right, it comes to a conclusion eventually, even my webinars. So some conclusions. I hope you had the stomach to bear with me through all those slides and sometimes quite complicated topics. But just to conclude, before going to the Q&A. So EU REACH, UK REACH, and Turkey KKDIK have these identical only representative concepts in place because they are essentially copies of each other's and therefore identical requirements. So if you know how things work in one of these regulations, then you know how things work in the other ones also. Companies that are outside of a said market, like the EU or Great Britain or Turkey, that manufacture a substance or formulates a mixture, have the right to appoint an OR. They don't have the obligation, but they have the right. And this only representative takes upon themselves the obligations of the importers with regards to these regulations on these said markets. Having an only representative is very efficient because it relieves your importers, so your customers who you are supplying to in the said market from outside the said market, from their registration obligations, as they will be simply regarded as downstream users. So this only representative takes care of all the importer obligations on their behalf. So this means registration in the EU, pre-registration and later registration in Turkey, and then, for example, a downstream user import notification in the UK or an inquiry, depending on the case, and later registration. Having this only representative makes it possible also to protect the composition of these confidential mixtures and other information also. So that's very good to understand. So, and as we saw, only representatives can also support indirect import. So that is very good to understand. But please be aware that the appointing company has to allow for it. The default is it is allowed, but in some cases they might say that they will not support indirect import. And then good to know that there are solutions available if you are not in a position to appoint an only representative. So there are this special appointment, what we call a special OR appointment procedure, but that the drawback is that that still requires at least the one appointment document to be signed by the upstream manufacturer and formulator. But if that is provided, then it gives these actors similar level of regulatory control as the only representative. And these are services we are already providing to some of our clients, just for your information. So we stand ready to support, of course, you in your chemical regulatory compliance efforts, whether it be only representation requirements and so forth, all the associated requirements. We do that for, of course, EU REACH, UK REACH, and Turkey KKDIK natively, and for other regulations when they enter into force or through our partner network. So please, as maybe a call to action, it doesn't cost anything to send us a request for quotation for services. Please do so already today if you are in need of. You can contact sales@reachlaw.fi or directly me, fredrik.johansson@reachlaw.fi, coming up in the last slide of this presentation. Okay, coming to the Q&A. So we're 50 minutes over time. Sorry for that. We got some questions ahead of the webinar, so I'll just go through those quickly. Some of those were not related to only representation, so I will not answer those. We will come back to you separately on those. Maybe one of those could be taken up. For example, can we use EU REACH registration data for Turkey REACH registration? So yes, you can. The lead registrant will coordinate this effort in their joint registration activities and define what the information is you share with them, and what is the compensation for that information, and ultimately what is the cost you have to pay to join this joint submission. So absolutely, you should utilize existing information that you have for EU REACH purposes for other chemical regulatory purposes where you are permitted to do so. So one question related to only representation. So options related to purchased polymers when vendors will not provide only representative coverage and will not provide ingredients information. Well, obviously in that case, I would first try to switch suppliers. If that is not possible, try to convince them to appoint an only representative. But if they do not, then say that, okay, we will need to do the appoint the only representatives ourselves if we are a formulator, for example, of a polymer in a product, and then beg for information about the substance. If they still don't provide it, then you would have to do testing on the polymer and try to figure out, of course, you probably know what the monomer is, and try to then do several tests on a similar monomer, and thus get the information required for doing your registration. This is very tricky. We know of these situations, and of course, at the end of the day, if no information is available of the substances to be registered, then of course a registration will not be possible. I would still recommend to having the dialogue, trying to find alternative suppliers, and of course, for more details, please do contact REACHLaw. Maybe we can set up a call to discuss these cases in more detail. Then there was a question also. I only know of a consultant XYZ. Will not mention any competitors in this webinar for KKDIK purposes as an only representative. Then the question is, does REACHLaw help in appointing other companies as a KKDIK OR? So absolutely, we can help you in appointing another OR, and of course REACHLaw is happy to provide only representative services ourselves, because we do those and provide those for Turkey through our office in Istanbul. So please feel free to contact us for quotation for helping you change your OR to REACHLaw, for example. Okay, then looking at some of the questions received. So we got a lot of questions ahead of the webinar, but they're somehow not OR related, so we'll come back to those separately. So looking at some of the questions, if you just give me a minute, then I'll try to browse through those and pick a few. We're so much over time that I will just pick a few to go through. Okay, first question. Could I ask you, please, which tool do you use for volume tracking of chemicals? So we have our own volume tracking system at REACHLaw, developed specifically for this purpose. So this is generally a tool that we use for our own purposes. But if there are any extensive needs for volume tracking, then we are open to discussion about how this tool can be used for external purposes. So there is no tool, one set tool that you can use. In some cases, we know of certain only representatives managing this via Excel, but it is manageable up to 20 or 30 substances. But when you go over that, it's not manageable anymore. So as we are representing hundreds and in some cases thousands of substances, we have to have an IT system to do this, and that this is our volume tracking system that we have developed by ourselves for this particular purpose. Then another question. Oh, there's a question about what is the total average cost of appointing an only representative. So again, in this case, I would it's very case dependent. What substances, how many substances, for what market, and so forth. So I would recommend just asking for a quotation for your particular specific case, and there you will see all the costs broken up as far as possible today. So I just recommend contacting REACHLaw to get a quotation for these services. It doesn't cost anything to ask for a quotation, as mentioned, except of course at our end when we spend our time preparing these. So don't ask unless you have a sincere wish of having these services, of course. Thank you. So then there's a question about the slides. So we do not provide the slides, but you will be able to see those, for example, on YouTube, and of course you can pause the videos as much as you like. But if there's a dire need for the slides, we can make some exceptions. But we'll see. We've determined that on a case-by-case basis. Then let's see. There are a lot of questions. I will just take one more, I'd say, which is fairly representative. So one question is, if in future a manufacturer wants to register the same substance, are they forced to use the same owner representative? So register the same substance. I guess you mean now for another market. So absolutely not. It is not necessary to of course have the same OR for different markets. If you cease manufacture, of course, you could essentially see that as stopping the manufacture. Then if you restart the manufacture, you could see that if you want to continue with the manufacture, then of course you already have a registration in place. But I think in this case, of course, just important to note that yes, you can change only representatives, even for registered substances. It is possible, albeit it's not specifically mentioned in law. It is possible to do for EU REACH, for UK REACH, and Turkey. As said, for UK and Turkey, it's a bit more work and manual work, communication with the authorities, but it is absolutely possible to do. Let's see, do we have one easy question? And someone says it's a very interesting presentation, so thank you very much for the compliments. Okay, this is a favorite one, albeit not specifically for only representation, but for the other questions that I have not answered, we will come back to you separately. I'll consider maybe preparing a Q&A document also. Emphasize the word consider. If not, then we'll come back to you specifically for those people who have asked this question. But the last question is, do you know if the registration deadline of KKDIK end of 2023 could be postponed by authorities, and in case when? So last week, actually, we had a discussion through the association in Turkey we are a member of with the authorities, and they were very clear that there will be no postponement of the KKDIK registration deadline. If for whatever reason there would be a need for postponement. I'm pretty sure they would not tell us that until the last possible moment. So for all intents and purposes, it means you should not bet on it. You should work as if the deadline is end of next year for Turkey, and it is end of next year. So that is my 5 cents of advice at this point. As mentioned, we stand ready to help and support you with all your compliance needs. So just let us know. We're happy to provide quotations and discuss further. So with that said, thank you very much for attending this very long webinar, and apologies for going over time. Nonetheless, I wish you a very nice day, and I hope you will join us for our next webinars in the fall. And of course, feel free to look at our past webinars on our YouTube channel, REACHLaw Talks. So thank you very much and stay safe.